A very good morning to you, and welcome to the live audio stream of the judgment of the full court of the Supreme Court in the matter of James and another against the Ministry of Finance and the Public Service and others. James was substituted for Rowe in the judgment, so that will be reflected in the written judgment. We are at present awaiting the arrival of the full court panel consisting of the Honorable Mr. Justice David Batts, the Honorable Mrs. Crescentia Brown Beckford, and the Honorable Miss Justice Tara Carr. We kindly ask that you stand by for the live judgment. Once again, welcome to the live audio stream of the full court judgment of the Supreme Court between Rowe and another against the Ministry of Finance and the Public Service. The judgment will be delivered this morning by the full court panel consisting of the Honorable Mr. Justice David Batts, the Honorable Mrs. Justice Crescentia Brown Beckford, and the Honorable Miss Justice Tara Carr. Please stand by. We're currently in the courtroom awaiting the arrival of the full court panel for the live stream of this judgment. The judges are now entering the courtroom, and we will begin momentarily. So once again, welcome to the live audio stream.
Is it? Yeah. Versus the Ministry of Finance and Public Service.
Good morning, my lords. My lord, Keisha Spence. My lord. And I have here with Mrs. Jacqueline Samuels Brown QC. Unfortunately, my lord, Learned Queen's Counsel is running a little late, my lord. And I expect her to be here any minute now, my lord. My lord, also, my lord, Miss Abigail Ferguson, my lord, an intern at the Norman Manley Law School, my lord, who is attached to our chambers, my lord. I seek the court's permission for Miss Ferguson to sit in, my lord.
All right.
The appearance, my lord, remains the same for the defendants, my lord. Oh, I yield to my friend, my lord.
Yes, Mr. Lindsay.
Right, we have managed to reduce our decision and reasons to writing. We will not propose to read it all, but given the public interest, I will reference a few paragraphs before stating our decision. In this claim, the Jamaica Police Federation and an individual member have had to sue the state and its agents because of, and I quote, frustration, to adopt counsel's words, caused by the state's failure to keep promises made. Also, unchallenged evidence reveals that the existing manual system for recording overtime in the police force is unreliable due to, again quote, integrity issues. These facts speak to and may in part explain existing deficits of trust within our society. Social scientists may one day consider the implications, if any, for governance in the Jamaican state. Now, on the first morning of this hearing, Queen's Counsel advised that there had been a change in the leadership of the Jamaica Police Federation. The named claimants, former office holders, were therefore, without objection, placed by the new office holders. Also, by consent, a bundle of agreed documents was put in evidence as exhibit number 1. The court was informed that the order for cross-examination notwithstanding, neither party required any witness to attend for cross-examination. The material facts were therefore undisputed and may be summarized thus. A. The Jamaica Police Federation, the Federation, is a statutory body established by the Constabulary Force Act. The Federation's chief role is to represent its members in respect of matters concerning their general welfare, as well as to enhance the efficiency of the force. The Federation is authorized to enter into negotiations pertaining to salaries and emoluments on behalf of its members. B. In the period September 2008 to December 2018, the Federation and the representatives of the state entered into 5 separate heads of agreement. Each agreement outlined, among other things, salaries and benefits due to rank and file members of the Jamaica Constabulary Force. And I list the agreements. C. The agreements were entered into between the Federation and others on the one hand, and the Government of Jamaica on the other. The agreements were intended to have legal effect and created a legitimate expectation among the members of the Federation that the obligations contained therein would be performed. D. The Federation and the government agreed, in the agreement dated the 11th September 2008, to establish a 40-hour work week for rank and file members. Where members were required to work in excess of that 40-hour work week, they would be compensated with overtime pay. The challenge was to design and/or acquire a system capable of accurately capturing the additional hours worked by those members who worked in excess of 40 hours. E. It was agreed that a system was to be provided by the defendants, which would replace the existing method of calculating overtime hours with one that was reliable. F. The agreement of 2008 also provided that the system was to be implemented during the contract period. See clause 46B, page 24 of Exhibit 1. The system ought therefore to have been established no later than the 31st March 2010. G. In the interim, and until the system was in place, all rank and file members would receive pay for an additional 10 hours worked, whether or not they in fact worked overtime. See clause 46A and B, page 24 of Exhibit 1. H. The new system has not yet been established, and the payment for the additional 10 hours, whether or not the hours were worked, has continued to date. The claimants contend that they are contractually entitled to have the system established, and alternatively, that they have a legitimate expectation that it should be done. The claimants also seek compensation retroactively computed from the 1st April 2008 to the present for overtime actually worked in the period. They therefore seek declarations and orders as well as damages. Now, it is well known that declaratory orders are not usually made by consent. This is because a declaration, either of law or on the interpretation of an instrument, although unenforceable, may have implications for others who are not parties to the proceedings. Therefore, before declaratory relief is granted, the court must apply its own mind to the issue, even if the parties are agreed. The court should only grant declaratory relief if satisfied that the construction of the instrument under consideration is legally correct and it is appropriate to do so. The declaratory remedy, being discretionary, is to be exercised judicially. An order of the court differs from declaratory relief in that it is readily granted by consent. Parties are free, so long as they are of sound mind and are adults, to agree to be bound in any particular way by the coercive power of the court. In this case, where the facts are not disputed and there exists a clear and unambiguous contractual obligation which has not been performed, there is no reason in law to prevent the declarations at 1 and 2 being granted. There is also a very good reason to do so, as it will make clear the precise legal obligation of one public entity to another in a matter that, if not clarified judicially, may have adverse consequences for the public interest. It follows that not only are the claimants entitled to the declarations at 1 and 2, but an order positing a time for performance is appropriate. This the claimants seek in paragraphs 19 and 20 of the amended fixed date claim. If such an order is not made, they would be forced to further litigate if the promise made this time is also broken. On the evidence quoted above, there is a very good basis to stipulate the time by which the obligation is to be performed. There was no argument made challenging this court's jurisdiction to make such an order. It is too late in the day for that. The orders are not against Her Majesty, but her servants and her agents. Similar orders have been held to be enforceable, and we reference 2 decisions at the highest level. In the result, the defendants will be ordered to comply with their contractual obligations within the period promised by their witness. The only other question is whether or not the claimants are entitled to damages. They seek an order for damages to be assessed. In this regard, we agree with the arguments of counsel for the defendants. The agreed 10-hour overtime payment, accepted until the system was put in place, represents agreed liquidated damages. The police officers agreed to accept payment for an additional 10 hours, regardless of the actual hours worked, because of the existing difficulties in measuring the actual hours worked. There is therefore no prospect of loss being established in consequence of the breach. By agreeing to accept payment for 10 additional hours, the claimants had in effect quantified their loss. We test this finding by asking whether, had the system been put in place as contemplated in the very first agreement, police officers might have claimed for overtime actually worked in the period prior to the system being put in place. The answer is clearly in the negative, because the agreement contained no such stipulation, and the claimants agreed in the interim to accept an assumed 10-hour payment. We agree also with the submission by counsel for the defendants that there is no scope for an award for, quote, constitutional damages. In this judgment, we have referenced the heads of agreement and contractual obligations. It may suggest that the claim is one in contract. In fact, the application was listed before the full court because the matter is framed as one seeking constitutional relief. The plea has been that even if no enforceable contract exists, a legitimate expectation was created by the heads of agreement among the men and women of the constabulary force. The defendants, to their great credit, conceded that the obligation existed and did not challenge this court's jurisdiction to hear the matter. They argued that, on the facts of this case, the claimants were not entitled to a remedy. We hold that assessment of compensation for the disappointed expectation would in this case involve similar considerations as are applicable to an assessment of damages for the breach of contract. Therefore, the payment for 10 additional hours similarly represents compensation for the disappointed legitimate expectation. There is no evidence suggesting additional or peculiar loss or injury consequent on the disappointed expectation. In the result, and for all the reasons stated above, which, as I say, I have not read all the reasons, but they will be available shortly elsewhere, we grant the following declarations and orders. A, it is declared that the heads of agreement entered into between the Jamaica Police Federation and the Ministries of National Security and Finance on behalf of the Government of Jamaica on the 11th of September 2008 for the contract period 1st April 2008 to 31st March 2010, on the 10th November 2015 for the contract period 1st April 2015 to 31st March 2017, and on 14th December 2018 for the contract period 1st April 2017 to 31st March 2019 are binding on the Government of Jamaica. B, it is declared that the heads of agreement referenced in paragraph A above, jointly and severally, constitute binding contracts between the parties and created a legitimate expectation among the members of the Jamaica Constabulary Force. C, it is ordered that the defendants, on or before the 31st of March 2023, put in place a system which is in accordance with the terms agreed in the heads of agreement aforesaid, and which will capture the actual hours worked by members of the Jamaica Constabulary Force in excess of 40 hours per week, and that the said members be thereafter remunerated accordingly for such excess hours. Costs will go to the claimants against the defendant to be taxed or agreed.
Milord, please, is it now for council to address the court?
Well,
You are finished, Milord?
I'm done.
Yes, thank you, Milord. First of all, I know I speak on behalf of all counsel for both sides, and certainly for on behalf of my clients, the Jamaica Police Federation and the particular representative, that we are grateful to you, my lords, ladies, for the indulgence which you have granted us in allowing us to have developed the arguments. And in fact, I'm also grateful to my learned friend, because in these adversarial proceedings, the input of the other side is always very helpful in helping us to refine our position and to give the assistance we can to the court. So we are grateful, my lords. We have taken note of your lordship's ruling and the orders made, and I will have to discuss it further with my clients, but we are grateful that at least one stage of the proceedings has come to an end, which is that it was not until this application, which was filed in 2020, came before the court, that we had the assurance that the system was now in place to compensate the police officers in accordance with the contractual obligations of the government.
So you mean that the financing for the system?
The financing for the system, if it pleases you, my lords. And in fact, that is the value of our courts, because very often it is not until a matter reaches litigation and the court, such as your lordships, becomes vested with the matter, that issues are resolved. So we are indeed grateful, my lord. I'm sure my clients would wish me to say that they took it for granted that the financial obligations, the contractual obligations which the government committed to, was on the basis of an assurance that the finances and the system were available and the system could be put in place expeditiously. But nevertheless, they were more influenced by their sense of duty to the country, and they put themselves in the back burner. But we are trying to ensure that the balance is kept in terms of their duty to the society and the government's obligations to them. So, in summary, we are grateful to the court. Thank you.
Thank you, Queen's Counsel. I'm sure my colleagues will join me in expressing our appreciation for the economy in which this matter was and the good, let's say, amicable and one would almost want to say friendly atmosphere in which the litigation was conducted. It made our task much easier.
Grateful, my lord.
Thank you very much. Mr. Campbell, can I adjourn court, please?
Please stand. This honorable request to adjourn. God save the Queen.
And there you have it, ladies and gentlemen. Thank you so much for joining us for our live audio stream of the judgment of the full court. We encourage you to continue to watch this space as we will continue to bring the courtrooms to you wherever you are. Have a pleasant day.
Don't sit, the seat is not there.